Please be seated. Good morning. We're here for oral argument in case number 1 CACV 16-0260 Buxton Arlington Pet LLC et al. Versus Ronald H. Butler et al. Council, just a reminder, these proceedings are being recorded both by video and audio recording, so we ask you to please identify yourselves and who you represent at the beginning of your arguments. Each of you will have 20 minutes. Appellants counsel, you're responsible to watch the clock and reserve as much time as you desire for rebuttal. Also, please keep in mind we've read the briefs, we've conferenced the case, so keep that in mind with your the points you'd like to make. With that, appellants counsel, you may proceed.
May it please the court. My name is Jim Marburger. I represent the appellant who is the defendant below, Ronald H. Butler and his spouse, Nancy Butler. The issue before the court this morning is one that comes up seemingly over and over again, and that is, when does a tort arise out of a contract under ARS 12-34101 for the purpose of an award of attorney's fees.
Let me jump right in, Mr.
Yes.
Marburger, because there's one issue that I seem to see as a big decision tree that governs perhaps the outcome or not. You're not arguing that Mr. Butler was a party to the contract, correct?
No.
So why wouldn't Morris govern here?
There are a couple of reasons. The Morris case was decided the same day as Barmat. Barmat set forth what the framework would be for deciding cases like this, and said very specifically that it's fact dependent.
But then we have Morris, which is, to me, strikingly similar facts, fraud and the inducement claims, and tells us that whether or not you're a party to the contract matters, I think.
And I think the problem with Morris is it's difficult to tell exactly what the fraudulent inducement was. The fact, in that case, the Hunsingers were apparently not employees of Aiken Construction. They were true strangers to the contract, and the fraudulent inducements or fraudulent representations didn't seem to have anything to do at all with the contract, other than the only thing that's really mentioned in the Court of Appeals decision is that one of the Hunsingers recommended the Aikens, but
then Morris goes on to say, talks about Sparks. Sparks demonstrates that fraudulently inducing one to enter into a contract with a third party is not the type of tort falling within the ambit of the statute. Isn't that what we're dealing with here?
The difference is, and I guess my response to that is you would end up with very perverse situations.
Blame the Supreme Court. But I mean, we have to follow what they say, and so I'm trying to see how we don't read that as supporting the Superior Court's ruling.
And I guess I go to the McAllister versus Citibank case for that. In that case, McAllister had claimed that Citibank had promised to renew a loan, and the claim was against Citibank. Well, Citibank isn't the one that promised to renew the loan. The loan was promised by an employee of Citibank. So the question is, if McAllister had sued the employee in addition to Citibank, would that mean that Citibank can recover attorney's fees, but the employee can't, even though the employee is the one that made the representations? In our case, the representations were made by the president and CEO about the terms of the contract in negotiations for the terms of the contract. And so it's like in Barmat, the court said, you can't draw bright line tests. And what Buxton's trying to do here is use bright line tests and say, well, if you're a third party, there's no way you can recover. I would submit that in some cases that would be true, but not in every fact situation. And the Barmat court, the quote from the pornography cases, we can't really define what a tort is, but we know it when we see it. And in this case, the representations that were made were so bound up in what the contract was that you can't have a tort without a breach of the contract.
But counsel, give me an example where the fraudulent inducement wouldn't be bound up with the contract. I mean, that's the whole nature of the claim, right? You fraudulently induce me to go enter into a contract. You're necessarily going to be talking about the contract.
I'm not sure that's necessarily true. For example, if someone, in this case, if there was a true third party that, say, owned a parcel of land, and they made representations about the Buxton company and were telling Buxton, you really ought to do this deal because this third party wanted to sell the parcel of land to Buxton. So then they made false representations to try to get Buxton to do the deal with Pet Resorts. But their real purpose was to try to get Buxton to buy land from them. That, to me, is the true third-party situation where they're...
But let's go to what's the nature? Where's this duty coming from for this claim for fraudulent inducement and misrepresentation? That's coming from the restatement of torts, isn't it? Just like in Morris?
It's all torts come from
the common law.
A tort
Duty.
law. But the question is, does that duty arise from something that was in this contract, or is it implied in the law? For example, implied in law. Strict liability cases, a seller has a contract.
We go to legal malpractice cases, and we talk about all of those that it's implied in law duty. How is this duty different in this case?
This case is different because there's no way that there could be a tort without a breach of the contract. And that's really the test that Sparks and Barmat and all of the cases in the Supreme Court really lay out, is if the tort could not exist but for a breach of the contract, then attorney's fees are awardable.
The test Morris would have come out differently. I mean, Morris goes on to say there's no contention that the contract is invalid. This is wholly an action for damages for fraud where the alleged fraud is claimed to have resulted in one party entering into a contract with a third party. Nothing in the statute justifies an award of fees.
The difference in Morris is that there wasn't a breach of the contract necessary in order for there to be fraudulent inducement, at least from what I can tell from the limited amount that's discussed about the claims against the Hunsingers. This case is different because the claim was that there was going to be this line of credit available to pay. And you can't say that the line of credit was not available unless the contract was breached. In Morris, one of the things the Morris court says is that in a typical fraudulent inducement claim, evidence of the tort does not also prove the breach of the contract. In this case, it does, though, because if you prove that the line of credit was not available, then you've also got the breach. The breach of the contract, the non-payment of the loan is a necessary fact to determine.
The duty doesn't depend on the contract. Getting back to Judge Brown's question, the duty stems from common law principles, a duty implied in law not to defraud someone. So where do we look? At what point along the line? Don't we look at where the duty stems from to determine what the cause of action is?
I guess this is kind of a chicken and the egg kind of a situation, because the duty doesn't exist in this case unless there's a contract. And I guess the problem is the duty is so intrinsically bound up in this contract that you can't really say that there's a duty to disclose information without a contract. You can't say that there was a duty to say something about future performance of the contract if there wasn't a contract. And, the cases that have been cited by Buxton are different types. They're statutory duties. They are duties implied by law, such as intentional infliction of emotional distress. That has nothing to do with the contract. There are duties for interfering with a contract. Those can be breached even though the contract isn't breached, because that can be an expectation. But the courts uniformly, the Supreme Court has said this is fact-based, and you have to look at the facts and the circumstance to determine, is this the type of an action that a tort claim is intended to redress, or is it a contract claim? These were essentially promises. And the other thing that we argued below that the court didn't ever need to get to, because the summary judgment was based on statute of limitations grounds, was that this really is in the form of a contract expression rather than a fraudulent misrepresentation in the first place. And that is because what they were really claiming was that Pet Resorts would pay its debts in the future, and future promises don't fall within fraud claims. So the type of claim this really is a contract claim. I believe it was the Ramsey case gives the indicia of what a tort claim is. And those are, what's the nature of the defendant's activity? Well, here it was a contracting activity. It wasn't something like selling a chattel or those types of situations. Special relationship between the parties. The only relationship between the parties here was the president and CEO who was negotiating for his company to enter into a contract, and then the type of injury threatened. And this isn't the type of injury that is wide-ranging. The Ramsey court said that typically when it's a contract claim, the harm is between the contracting parties, and that's what we have here. In a tort claim, it's anyone within the foreseeable range of the harm. So
when you get back to, hold on, the harm is between the contracting parties, but you've already conceded that Butler isn't a party to the contract. So explain that to me.
He's not a party, but the only reason he's not a party is because he's an individual. He's negotiating for his company, and if he had been a sole proprietor of that company, then he would have been a party. So to me,
that's why people form corporations, though. I mean, to insulate themselves from personal liability.
But that's not what this case is about. This case is about.
But I'd like to go back to Morris for just a second, and this language, because you've said several times, and I don't disagree, that it's factually driven. But however, there's two sentences here that the Supreme Court, these don't seem like they're based on the facts. They seem like general principles. It is clear that the tort of fraudulently inducing one to enter into a contract can be committed without there also being a breach of the contract itself. Indeed, the tort of fraudulent inducement would necessarily be completed before a breach of the contract could occur. Oh, isn't the Supreme Court drawing a line there and saying, I mean, you said that they're not drawing bright lines. It seems like they're drawing a bright line there.
We can take little statements in all the cases and try to say that that's the bright line test. But they've also said that you have to look at the particular facts and circumstances of the case. The Marcus case, for example, was a fraudulent inducement case. If the Morris case means that you can never have fraudulent inducement and have it arise from a contract, then Marcus was decided wrong.
Well,
and
the
it
court
was
takes that up in its last paragraph, but yeah.
Well, and that's I guess exactly the point is they say in that opinion, they could have come out and said fraudulent inducement cannot support a claim for attorney's fees, period. That would be a bright line test, but they didn't do that. They went on to say Marcus, however, is a fraudulent inducement case where you can award attorney's fees. And so my position is I go back to the test that starts with Sparks and goes throughout all the cases, including I guess the most recent one is the Division I Carruthers versus Underhill, which is very similar to our case because that was truly a third party. Essentially the test is, but for the breach of the contract, could this tort exist? And the answer that I have is that no, it could not, because you can't have a tort without the non-payment of the rents, because the specific tort claim was that the representation was in the future this line of credit will be available to pay rents, and it wasn't. One other thing I would mention, and it wasn't really highlighted, but this is similar to Carruthers as well. This was also a case for aiding and abetting the conduct of pet resorts. They claimed that Butler aided and abetted the fraudulent actions, fraudulent inducement of the company itself. I know Mr. Bray has argued that, well, it's a derivative claim. Well, ours is too. He was sued for aiding and abetting what the company did. So if the company is not a third party and could recover, then the derivative action for aiding and abetting would seem to qualify as well. I'll reserve my meager 3 minutes for rebuttal.
Thank you, Counsel.
Good morning. May it please the court. My name is David Bray. I'm with the law firm of Dickinson Wright, and I represent the plaintiffs' appellees, the three Buxton entities. I'd like to start with picking up something that counsel for appellants said, which was there was no evidence or no indication in the Morris decision that Mr. Hunsinger was an employee of the contracting party. That is on page 508 of the Court of Appeals opinion. Quote, involved in the construction of this project as employees of Aiken were Brett Hunsinger. And of course, Mr. Hunsinger is the non-party to the contract that a fraudulent inducement claim was brought against. Counsel for appellants emphasizes that the court shouldn't apply a bright line test. I would use a different analogy involving light, and that is there's very, very little daylight between the facts of this case and the facts of the Morris decision. In our case, the complaint does not contest the validity of any alleged contract. Same as in Morris. Doesn't allege a breach of contract claim at all in our case. In the Morris case, there was no breach of contract claim asserted against Mr. Hunsinger. We're not seeking damages arising out of breach of contract. Same is true in the Morris case. In fact, in the Morris case, the Court of Appeals accepted the very argument that appellant's counsel is making in this case. The Court of Appeals said, quote, "The only damages that the Morrises are seeking redressment for are those for breach of contract. Therefore, the Morrises' claim for fraud against the Hunsingers could not exist but for the breach of contract." In the language that Judge Brown read earlier, the Arizona Supreme Court specifically rejected that reasoning. It said, well, it said, "It's clear that the tort of fraudulent inducing one to enter in a contract can be committed without there being a breach of contract in stealth. Indeed, the tort of fraudulent inducement would necessarily be completed before a breach of the contract could occur." And the court also emphasized that this argument regarding damages was a non-starter.
But how do you distinguish the statement you just read? What about why would the court have not applied that sort of bright line rule in the Marcus case?
Well,
That involved fraudulent inducement.
I would argue that there's two bright line rules established by the Supreme Court in the Marcus case and then the subsequent Morris case. The bright line rule in the Marcus case is if you're suing for fraudulent inducement to invalidate a contract, the Supreme Court says that arises out of contract under 12-341-01A. On the other hand, the later Morris decision of whether they intended to narrow Marcus or create a subset or a second category of fraudulent inducement matters, I would argue that the Supreme Court in the Morris decision made it absolutely clear by the language that you read, which again was not tied to the facts of the particular case, that when you're seeking damages for fraudulent inducement and it involves a third party to the contract, the duty arises at law and not from the contract itself. And that's what we argued in our response brief under Sparks. The real test is whether the duty arises under law independently of the contract itself. And again, the Morris decision could not be more crystal clear that the duty arises under law. With regard to this argument that, in this case, the fraudulent inducement is tied up in the contract, well, the claim in Morris was for fraudulent inducement of contract. The claim here is fraudulent inducement of contract. It's a recognized tort claim under the restatement under Arizona law. Contract is in the name of the tort. Every case that involves a fraudulent inducement of a contract involves a contract in some manner. That doesn't mean, as Morris made clear, that the matter arises under contract under 12-341-01A.
I find a distinct difference in Morris. The facts of this case are every action taken by Butler was taken on behalf of PRI, who is a contracting party. Unlike Morris, he was involved in negotiation, he got his information from the principals, all of the actions he took were on behalf of the company, and he actually signed the contract. So if we go with what you're saying, doesn't that subject every CEO or president to tort liability for entering into any contract? And especially in this circumstance, your client was poured out on statute of limitations.
Statute of limitations, yes.
So we're just going to let people willy-nilly sue presidents of corporations?
Well, no. I would argue that this case is on all fours with Morris. In Morris, the homeowner that had a contract with Aiken, and again, Hunsiger was an employee of Aiken and allegedly fraudulently induced him to enter into the contract. In that case, Mr. Hunsiger prevailed on the fraudulent inducement claim. The jury found that he was not liable for fraudulently inducing the contract. It may have been because he was an employee of Aiken. It may have been for other reasons. In this case, I'm not saying that Mr. Butler didn't have potential defenses to the claim for fraudulent inducement of contract. I'm appellate counsel. I was not the counsel that brought the matter below. Mr. Butler was successful on one of those defenses, statute of limitations. He may have been successful on a motion to dismiss on any of the other defenses that he raised. I don't know. But if the claim is brought against, if a claim like this one is brought against an executive like Mr. Butler, and there is a no good legal basis for it, that doesn't convert the claim into one under contract by ignoring Morris to say that a fraudulent inducement claim falls within 12341 when Morris says that it doesn't. There may be other grounds that a successful executive in this situation where there is a claim that's unsuccessful could recover attorney's fees. There might be 1234101C. There could be 12349. I don't know. But the mere fact that Mr. Butler was successful does not, turn Morris on its head and say, this claim was not pled as one for a fraudulent inducement of contract.
And if we go back to Morris, you say Hunsinger was a employee of one of the contracting parties. That is different than this in that Butler was acting as PRI. How do you parse out that difference?
Well, whether I could parse it out or not, I accept counsel's indication that, in his opening brief, he refers to the Supreme Court Morris decision as pro forma or short. I forget the exact word he used. There are facts that are laid out in the Court of Appeals decision, but not all of the facts regarding what exactly Mr. Hunsinger said, what exactly Mr. Hunsinger's role was with Aiken other than an employee. Was he an officer? Those facts aren't developed. I would just say that the underlying prohibition, or the underlying, I should say, direction in Morris, that a fraudulent inducement claim where you're not seeking to invalidate a contract, but you're seeking damages against a third party, and again, I don't think there's any dispute here that Butler is a third party, does not arise out of contract under 1234101A. And if there is any, what's the word I'm looking for? In terms of, your concern, Justice Campbell, why would this not be open season on CEOs? I would just say there may be other grounds that somebody in Mr. Butler's position could have recovered attorney's fees in the court below. But one ground is not 1234101A because of the Supreme Court's clear direction in Morris. While I didn't say there was no daylight between the Morris case and the facts in our case, I'd say there's extremely little daylight.
When we look at the facts, and it's a fact-driven inquiry, what we have is PRI filing for bankruptcy and basically being an empty pocket in Texas. So then PRI comes to Arizona, and instead of suing Butler in his representative capacity for breach of contract, they file their claims in tort. Not necessarily that they did it on purpose, but couldn't someone simply file a breach of contract claim in tort against people that were involved in the negotiation of the contract to skirt the provisions of 341?
I'm not 100% sure so you're asking, couldn't they have sued Mr. Butler for breach of contract in tort or bad faith contracting? Or
had they been successful in Texas?
Yeah.
And included Butler in the suit in Texas, they necessarily would have had to file for breach of contract. Agreed?
They would have.
They did.
Yeah, they did file for breach of contract against PRI, Pet Resorts International.
So we agree that that was a breach of contract claim tied in with tort claims, correct?
In your hypothetical where they sue Butler as well?
Correct.
I agree that yes, there was a breach of contract claim tied into tort claims, but I would also say that in Morris, there was a breach of contract claim against the contractor tied in with a tort claim against its employee for fraudulent inducement.
Against its employee representative capacity negotiating contract. That's where I'm getting hung up. Don't you see a difference between, hey, come hire my boss who does contracting to build your house, and, hey, I am the president of PRI. I'm here to negotiate this contract on behalf of my company. Do you see any difference between the two?
I would just say I see very little daylight between the two. And again, the facts in Morris, even in the Court of Appeals decision, are not articulated as well as they could have been, I suppose. But in that case, it seems that Hunsinger was more than an employee of Aiken, that in fact he had his own contracting firm that was involved in it somehow. So I would say maybe Hunsinger is not the equivalent exactly of Butler because we know more facts in this case, but it's very, very close.
I guess I'm getting hung up on the difference between Hunsinger owns his own contracting company, so maybe he's a sub of A, B, C, one of them. When we're talking about A, B, C in Morris, which is not the best way to go about explaining this, but we talk about A induces B to enter into a contract with C.
Mm-hmm. Yes.
Which is basically what it says. How can A not be... I'm having trouble with the division between A and B here. If you have a subcontractor in Morris inducing you to hire the general that I typically work for, and you're not involved in contract negotiations, here we have A, and I'll call it A plus, enters into a contract with B, plus being Butler, the representative of, who negotiated all of the terms to induce him to enter into the contract. That's what I'm struggling with. Does that make sense?
It makes sense, and I'm not going to fight Your Honor that I think there is a little bit of daylight between the facts of Morris and the facts as we know them here, and part of that daylight is because, as counsel said, not all of the facts are thoroughly elucidated in the Morris decision as they are here.
Well, that brings up the question. I mean, does Morris foreclose a factual inquiry? Morris, arguably, you could say, sets a bright line standard that if it's a third party, no fees under the statute. If it's a party, fraudulent inducement tort claim, yes. But what I think I perhaps hear Judge Campbell talking about, and possibly appellant's counsel, is that in itself a factual inquiry? Do you look not just that they're a third party, but do you look at what their role is, or do we have a bright line?
I've been practicing in this jurisdiction for 27 years. I don't know how many disputes I've had after trial as to applications for 12-341-01A. I don't know how many times I briefed the Sparks decision, the Ramsey Med decision, the Barmatt decision, the Morris decision. I would argue that this area of law aches for a bright line test. And I would argue...
Or your employment act.
Judicial Security Act. Yeah.
Good point, Judge Brown. Because oftentimes the amount of money spent on litigating fees and fee applications doesn't approach what the underlying fees are in the case, but it becomes significant. And to me... If
the appellant wins here, there's no guarantee they'd get fees below.
I understand that because it's discretionary.
You know.
It's not a mandatory contract clause. But I would argue that between Morris and... sorry, I'm just drawing a blank as to the earlier case. Morris and Marcus, that they should articulate a bright line rule. And the bright line rule is in Marcus. If it's a fraudulent inducement of contract claim to invalidate a contract, the Supreme Court says that falls within 12-341-01A. If, on the other hand, and I'm basing this on the exact language that the Supreme Court, in its opinion, articulated that you quoted, Judge Brown, if it's a claim for fraudulent inducement of contract where you're not seeking damages for breach of contract, then that, because the duty arises independently of contract, that falls outside 12-341-01A. Again, speaking as a practitioner, despite Judge Brown's comment that it is somewhat of an attorney full employment act, I would argue that this area of law aches for at least one bright line test, and I suggest that this be it. And I think there's a sound footing for that bright line test based on the language that you quoted in the Marcus decision. And with that, I don't know if I can reserve my time but I think I'd like to end there,
Any questions?
unless you have any more questions for me.
No, thank you,
Thank you.
counsel.
Thank you.
Thank you.
I'd like to discuss, I guess, 3 or 4 things that came up, but I have to do it real quick. So first, Hunsinger. There were a number of different Hunsingers, and I'm not sure whether the one that was the employee of Aiken was still in the case. In the Court of Appeals decision 155 Arizona 521, attorney's fees for Brett Hunsinger, who was the employee, it says Brett Hunsinger was a plaintiff in his own name in the original lawsuit. By summary judgment, he was taken out of that lawsuit. So my interpretation is that the only ones left were the Hunsingers who were not employees of Aiken Construction, whether that matters or not. But Hunsingers, there were 2 Hunsingers and a Hunsinger Homes that were somehow in the lawsuit, and I'm not sure exactly why, based on the information. I would submit that there is very little daylight between Marcus in our case. The only difference is that Marcus was the contracting party. And so if these cases are going to be decided based upon whether it's the president of the company or the guy in his own capacity as a sole proprietor, then I think that's the wrong analysis, and I believe that the Supreme Court's admonishment that these cases need to be decided on the particular facts and circumstances should trump that idiosyncrasy, I guess. It is true that a contract somewhere in the realm of the tort claim is not enough. This one, the contract was part and parcel of this tort claim. The question is, could Butler have been sued without a breach of contract? Could someone have come along and said, I'm going to sue Butler for misrepresenting that the line of credit was going to be available to pay rents if there hadn't been a default on the rent? And I would submit that that claim could not be made. And that's what the test is. If there's a bright line test, the test is, could the tort claim exist but for the breach of the contract? And in this case, I would submit that it cannot, because you have to have that default. The other thing very quickly is Judge Brodman decided the statute of limitations based upon the fact that the statute of limitations began to run on the date that the default occurred on the contract. So if that's not tied up together, I don't know what is. Thank you.
Thank you, counsel.
Thank you guys for a very thorough briefing and a very interesting issue.
Okay. Thank you both for your arguments. The court will take this matter under advisement and issue a decision in due course. Thank you.